Okay. Hi, good morning, everyone. Today is Tuesday, March 26, 2024. The time is 9:30 a.m. This is a pre-hearing conference in the matter of Robert Devine, case number 2024-004-S, before the Massachusetts Peace Officer Standards and Training Commission. This is a public proceeding and proper notice has been provided. We are convening remotely via Zoom today, and this pre-hearing conference is currently being recorded. The Honorable Kenneth J. Fishman will be the presiding officer over the pre-hearing conference today. My name is Alex Utz. I'm a legal fellow for the Post Commission, and also present on behalf of the commission, we have Lizzie Smith, who is our hearings administrator. With that, the matter is now before Judge Fishman.
So, good morning, counsel. I'm going to ask counsel to introduce themselves and the parties they represent, please.
Good morning, Shaun Martinez for the Division of Standards of the Post Commission.
Good morning, Your Honor. Robert Stowe on behalf of Robert Devine.
Thank you. And I gather Mr. Devine is not participating today.
I had encouraged him to, and I think there may have been a problem with the link. I got the link late. I just
really?
sent it to him, so I don't know that he got it yet. But
he's obviously not required to, but he's
right.
Welcome to. Are you reluctant to begin before he?
No, I'm fine. I'm fine beginning with him in his absence.
All right, great, thank you. All right. So I've received and I appreciated the pre-hearing memorandum prepared and reviewed that. I also have received a proposed protective order, and the only other document other than the show cause order and prior documentation that I've received is the respondent's motion to conduct discovery. Let's see. So let me just ask you, why don't I deal with what I've got in front of me? I have read the protective order and seen from your memorandum what the basis is, and I gathered that the parties are in agreement with regard to the protective order. Is there any dispute regarding its coverage or wording or any of that?
No.
No.
Okay, so we're gonna enter that order. Have counsel signed off on it yet?
We have not. I think we. I'm sorry, Shaun, you submitted. So.
Yeah. Yes, Your Honor. So we were waiting for your approval before signing it.
Okay.
But we can sign it before Your Honor does it if needed.
I mean, generally that's probably wise. So if you don't mind, why don't you folks get it signed and then we'll have it signed right away. Certainly, has this resulted in certain documents not yet being provided, I gather, until the order was in place?
Correct. There's
yes, that's
okay. Either one of you.
Go ahead, Shaun.
So yes, we do have some electronic exhibits that were associated with the internal affairs report. Once the protective order is issued, we should have no issue sending those documents over, likely within the next day or two.
All right, very good.
If I may add, Judge, there's a notation in some of the records I did receive that there's a flash drive with some 50,000 pages of documents. So I'm sure, based on the volume of documents, it could take a little bit for us to get through them, for me and my client to go through 50,000 pages. So as far as scheduling goes, that's going to be a concern for me. I'm a sole practitioner, and I've got to meet with my client and go through what is quite voluminous, and he does have an active role in this case. I know he's not here right now, but I think that's really a communication.
Yeah, no,
last minute.
I'm sure we'll definitely take that into consideration for scheduling future matters. That's appropriate. But in terms of the protective order, just for the record, I will be allowing it once counsel signs that. Lizzie, all right? Well, thank you. And I gather from it seemed, but I don't want to assume anything, from the pre-hearing memorandum that the respondent's motion to conduct discovery apparently is in the process of being resolved, essentially. It looks like you provided Enforcement Council provided a lot of discovery to date, and upon the execution of the protective order will be providing additional documentation and other discovery. I guess my question is, are there any matters that remain in dispute with regard to discovery? And I realize that respondents' counsel may not be able to answer that until you receive what you get. But at this point, is there anything in dispute that we ought to be talking about?
I don't think at this point there's anything in dispute. I do hope to conduct some keeper of record depositions from the town of Stoughton, and perhaps military. I'm sorry, the military recruiters. Apparently, as far as the matter as it involves Ms. And allegations which seem to be the forefront of this case against Mr. Devine. There are newspaper articles that she had relations with her military recruiter. There are other allegations that she's had, that I've heard that she's had restraining orders against her by other persons. I know of at least one restraining order. I put that in my memo that I've seen. It involves a third party not related to any police organization that's involved repeated assaults on her. So there's some other discovery that may be necessary and that will be necessary as far as keeper of record depositions go. I don't know the full content of what I'm going to receive, but I do know from the newspaper articles that a lot of the information may still be with the town of Stoughton, that none of us may have seen or may have been transferred to the state police. So
let me interject for one moment. I just want to be careful, and I'm alerted to this because of your protective order, but my understanding was the parties were going to be careful about referencing the individual involved and using initials.
yeah,
I think.
Sorry, Judge. Yes.
Yeah, I just obviously I just want us all to be careful. This is a public proceeding here, and that's and it's being recorded for that purpose. But beyond that, let me ask you, we don't really need to exactly resolve it yet because you're not sure yet what you're going to be seeking. And I understand that. And I understand you're receiving a lot of additional material that may generate further requests. And that's fine too. Yeah, but I'm just curious about, sort of the procedural aspects of our hearings are developing as time goes on because the statute's relatively new, the process is relatively new, as you folks know. But I'm interested in the thought, do you have an initial view, Mr. Martinez, on the rights of parties, for instance, to conduct discovery depositions such as Mr. Stowe was suggesting, keeper of the record deps?
Your Honor, I do believe that under 30A, they are allowed. However, I will note that I don't believe in this particular case it would be necessary. I expect that if there were any issues as to authenticity, that the keeper of record should be able to testify at the hearing. The records that we're going to be turning over today came directly from the Stoughton Police Department. There were no intermediaries. We got a copy of their data, and we'll be turning it over to Attorney Stowe.
Well, let's just see how that plays out. You can figure out whether you are going to seek to pursue it, Mr. Stowe, after you get what you get. All right?
Yes.
Okay, good. Okay. Are there any other pre-hearing motions that have been served and filed at this point other than what I've referenced?
No.
Okay. And other than what may develop from discovery, are any others anticipated at this time?
Other than what developed from discovery, none. There will probably be some motions relative to motions to eliminate for the hearing itself. But as far as discovery, I don't know until I as you want to indicate, I've received what I receive and can go through it.
From the from enforcement counsel's perspective, are you anticipating, other than perhaps motions in limine, anything else being filed?
I don't anticipate. No, I don't anticipate any other motions than the in limine motions.
We've addressed already some of the sort of confidentiality aspects of it that have generated the protective order, but are there any other agreements regarding stipulations or exhibits or confidentiality issues that need to be entertained at this time?
None.
No.
Okay. And this may be, in view of the ongoing discovery, this may be premature as well, but let me ask whether you've met and discussed any disputed evidentiary issues or the proposed exhibit lists or any objections, or is that just simply not happened yet because of the ongoing discovery?
It hasn't happened yet because of the ongoing discovery. I did send over a list of issues I had with what was produced, which resulted in our coming to the agreement on the protective order. So once I get the discovery, I'll be able to more adequately respond to what issues I have.
Okay.
Any.
And directed on your scheduling order, each party is going to be required to serve and file respective witness and exhibits lists no later than 7 days before the adjudicatory hearing. We'll discuss about when we need to set that date in a moment, but as you complete the list, you're going to be asked to identify any issues with the witnesses relating to competency to testify. And if you're aware of any, you want to inform me at the time that it's being submitted. And of course, if you have any questions along the way, you can contact Hearings Administrator Smith. And I'm sure you both have her contact information.
Yes, I believe so.
Yes.
She's really the boss. She's the boss. I'm a figurehead here. She's the one. Okay. And likewise, pursuant to the scheduling order, you'll provide any stipulations of law and fact as we get up to that pre-adjudicatory hearing process. So also pursuant to the notice of pre-hearing conference, you were instructed to come prepared to discuss the following issues. One is the possibility of and/or any progress toward resolution. Again, I can understand that some of this stuff may be happening. It's difficult to discuss with the absence of full discovery being received and reviewed. But have there been any discussions along those lines?
No, I put in my memo at paragraph 2 that until we can review the evidence, we can't really discuss moving forward with the resolution because we don't know what the evidence is against us. My client hasn't even seen, to this date, he hasn't seen a full unredacted version of the internal affairs report. So he hasn't even seen what the report says again about him in total. So
is that because of awaiting protective order, or is there other obstacles, or you haven't received it?
we're waiting for protective, so we haven't received it. I haven't received a version I can give my client.
Okay.
I will tell you, Your Honor, there's a civil proceeding out there, and in a civil proceeding, there's an order as it stands from Judge Davis that the full unredacted internal affairs report cannot be given to any of the parties. So he hasn't received one in a civil case that's pending against him, and he hasn't received one, and he has had no access to one yet in this proceeding. So he hasn't even seen the report, the full report.
The Judge Davis's order precluded counsel from seeing a full unredacted internal affairs file.
It has allowed us to see the report, but there's still a terabyte of information that hasn't been produced. There's actually a hearing this afternoon at 2 o'clock wherein we hope to address some of these issues. But there's a lot of discovery that my client hasn't seen, and there's no formal order. There was an instruction by the court last year that the parties are trying to work on a protective order in that case. And the town has certain issues of public record that think should be public record, and the parties can't come to an agreement and haven't been able to come to an agreement as to what the protective order should say. So Judge Davis's instruction to us, it wasn't reduced to writing, but it was said clearly in open court, was that the parties themselves can't look at any of the unredacted records or documents until there's a protective order that's been filed or issued by the court. Although counsel can look at it, and through today, we still haven't received a lot of documents from the town that they're trying to put onto a drive. Council had to submit a 1 terabyte drive to the town, and we haven't received anything back yet. So we're still in limbo there. So at both sides of the fence, Mr. Devine is unable to look at the evidence the town has against him.
Well, are you counsel, Mr. Stowe, for Mr. Devine in the civil case as well?
I am.
Oh, okay.
And I can't talk to him. I actually have a motion. I circulated to try to get him access to the documents so that he can do discovery. I can't even do interrogatories with him. That was served on us 4 months ago. And that's been an ongoing issue. And Judge Davis is circulated out of that session. And I don't know who the judge is today, but we're hoping, all the parties are hoping that we can have a conversation with him about the new judge about getting discovery, because we're at a stalemate. And of course, my position is I have to have a meaningful conversation with my client about the case and evidence against him. And as it stands right now, I can't even talk to him about what's in the unredacted internal affairs report. So I can't even represent him effectively in either case because of the same reason.
What county Superior Court is this case? Is the civil case pending?
Norfolk.
Okay, makes sense. Okay. Well, hopefully you'll make some progress on that today in the hearing. I'm sort of required to ask as well whether about discovery issues and schedule. Again, we've sort of been saying over and over, that's a little bit hard to figure until you receive what you're going to be receiving shortly. And it may be also dependent on what you're able to share with your client by virtue of the civil case discovery. But I'm thinking that along the way, we ought to set up a further hearing after you've had a chance to get a hold of what you're going to get. And I get caught up on this so we can see so we can keep the case moving forward. Do you have any sense of sort of timing on that, Mr. Martinez? You have probably a better sense of the volume and nature of the discovery at this point than anybody.
So once we receive the executed protective order, I have everything within a folder in our within our drive, and I can copy it over and send it virtually to Attorney Stowe. Should he want it to be copied onto a hard drive, of course, once we receive the hard drive, we'd be able to copy it over. But I do expect to, once we receive the order within, I anticipate by tomorrow at the end of the day that I would be able to copy those over and send it to him virtually, to where he should be able to gain immediate access.
I suppose that while we're on the subject, why don't we schedule a further hearing? There's a few other things I need to discuss with you anyway, but I think this is sort of a critical juncture that could impact the timing of the adjudicatory hearing and other issues that may arise. So give me a sense, Mr. Stowe, about how much time you think before you can more fully address these issues you would need.
Well, Judge, I think to review 50,000 plus pages of documents, I probably need, given my continued schedule of other matters, probably 2 months to go through it. If counsel wants, I don't know if, from what Attorney Martinez just said, I don't know if he wants me to send him a flash drive, I mean, a drive, or it's something I can download to my computer. I don't know exactly what he's going to send me. If I may ask.
Sure.
Mr.
Yeah.
Attorney Martinez, is it, if you, what you send me, when the audience allowed, what you send me, is it something I can download from, say, a Dropbox or some other internet transfer service?
Yes, that's the plan, is for me to send it through a virtual folder so you can download it.
Okay.
And then should you for whatever reason feel the need to have, sort of the physical copy on a hard drive, if you were to drop a hard drive off, I could copy that as well. But my plan right now is to send it virtually, and hopefully there are no issues sending it through that means.
So I'm just wondering if there's gonna be some downtime in getting it, but what you're saying is no, there isn't, so that's good. Judge, I think 2 months for me to look at these the documents may suffice for purposes of having a follow-up hearing conference.
Any thoughts on that, Mr. Martinez, about scheduling that?
I think that makes sense given the volume. Again, even I, have not been through every single message or everything, single file. And I think 60 days is a reasonable amount of time for Attorney Stowe to have an understanding of at least what is on the digital files, and then certainly what relates to Mr. Devine as well.
Rudy, can we pick a date? Approximately 60 days out.
Sure. I'm just looking at a calendar now, and it looks like roughly end of May, beginning of June. Right.
Yeah, like
Second week of June would be best for me.
The second week of June. So how about June 4th?
That's
Or sorry, June 11th?
June 11th. Yes, June 11th is fine.
Okay, that's a Tuesday.
that work for you, Mr. Martinez?
That's fine
as
for me
well?
as well.
So I notice as
Yes,
you
it
all
does.
as you electronically check your schedules, we dinosaurs take our little black books and look at our paper calendars, but the 11th seems fine. Why don't we add that to the schedule, Lizzie, if you would, please?
Sure, at 9:30. Does that work for both parties?
Works for me.
It does.
Great.
And I would envision that really it's at that time that we could have a better sense of what needs to be resolved prior to the adjudicatory hearing, and we could schedule a date for the adjudicatory hearing at that time as well. What else do we need to cover today? Let's see. There we go. And I'm gonna withhold sort of pressing you on the other things that we usually cover at these, like anticipated disputed issues of law and anticipated evidentiary issues. Certainly that we did get some information about the names and addresses that I guess you had in mind so far, but agreed statements of fact and stipulations are all things that'll be more reasonably addressed in our June 11th hearing, as far as I'm concerned. Let me ask you, are there any other issues that you believe need to be addressed at this time? Ms. Martinez, is there anything else we ought to be discussing today?
No, Judge.
Okay. And, so anything further?
Nothing more at this time, no. I believe any evidentiary issues would be, as Your Honor said, would be more ripe for the follow-up hearing.
All right. I also have in mind, because I do very much want interested party, particularly respondent, to be able to participate if he wants to. And if you, maybe you can make sure ahead of the next one that he's able to get to join the meeting. If there isn't any problems with him, you can certainly just check in with Lizzie on that.
Yes.
Okay, good. All right, Lizzie, anything further we need to resolve today?
I don't believe so. Attorney Stowe, if it would be helpful, I can send the recording of this so your client can view, what was said during this
Sure.
pre-hearing.
So that'd be great.
Okay, great. I will do that after.
Thank you.
All right. All right. Well, thank you. There being nothing further, I think we'll simply adjourn this pre-hearing conference at this time.
Thank you.
Thank you.
Thank
Thank
you.
you, counsel.
Thank
Shaun, I'll
you.
give you a call. Shaun, I'll give you a call.